Colorado's Supreme Court has now ruled former President Donald Trump should not appear on the state's primary ballot. They said his role in the January 6th insurrection should keep him off the ballot.
But if there is an appeal to the U.S. Supreme Court, which is expected, then he will remain on the ballot until the Supreme Court does decide. Our 9 News political reporter Marshall Zellinger with us now. Marshall, the state Supreme Court affirming the lower court's ruling that Donald Trump did participate in the insurrection, but then they went a step further.
Yeah, in the 4-3 ruling, the justices said that Section 3 of the 14th Amendment does apply to the office of president. The lower court ruled that it did not apply. And that is the section of the Constitution that says you can be disqualified from holding office if you engage in an insurrection after taking an oath to support the Constitution. This split decision keeps us in limbo for a bit. If it gets appealed to the U.S. Supreme Court, Trump's name will be printed on primary ballots, and then whether or not he still gets the votes or is qualified to get the votes would be determined by the decision by the U.S. Supreme Court. Page 1 of the ruling from the Supreme Court says it all for us. A majority of the court holds that President Trump is disqualified from holding the office of president under Section 3 of the 14th Amendment to the United States Constitution. Because he is disqualified, it would be a wrongful act under the election code for the Colorado Secretary of State to list him as a candidate on the presidential primary ballot. But, as you said, Tom, the court stays its ruling, meaning it's on hold, until January 4th, subject to any further appellate proceedings, which means if it gets appealed to the U.S. Supreme Court, it will be on hold, meaning his name can appear on the ballot, and then a decision by SCOTUS, the U.S. Supreme Court, will ultimately decide what happens. 3 of the justices disagreed with the 4 majority. 2 of the 3 said our election law in Colorado is not set up to decide whether or not someone was an insurrectionist. The Chief Justice additionally said he was troubled that they were doing this in the absence of a conviction for insurrection, meaning in criminal court, because this was brought in civil court. There have been no criminal proceedings on the insurrection question, but a civil court, Tom, decided that he was an insurrectionist.
Marshall, there is very little these days that does not get huge reaction, but anything involving former President Trump, especially something with this kind of impact, will be seeing quite a bit of reaction.
Sure, we've heard from from the people who brought the lawsuit, which was a liberal group from Washington, D.C., along with 4 Republicans and 2 unaffiliated voters in Colorado. They've put out a lengthy statement, but one of the Republicans from Colorado is former state lawmaker Norma Anderson, who told me she can't talk based on the agreement they have with the lawyers, but that she is adding, "I'm delighted." Again, a Republican, one of the 4, trying to prevent Trump from being on the ballot in Colorado. I will say one other thing from this decision is that the majority decided that deciding whether or not he was an insurrectionist is just the same as saying, are you 35 years? Are you a U.S. citizen? The same qualifications that you must check off to be able to run for president in the first place. The 4 of the 7 justices said this falls in the same category for people to have a fair vote. And you're going to have a lot of discussion via statements from Trump supporters and the Trump side saying that is just not something for a Colorado court, civil court, to decide.
A decision from the state's high court that will see many more decisions on top of that. There is much more still to come. Marshall, I know you'll be talking more about this coming up on Next. Thanks for joining us.